Good evening. This evening, I wanted to spend some time talking to you about Module 7, which is dealing with search and seizures. I'm going to share screen here and see if I can make this work the way I want it to. I'd be right here. Okay. So I think that I've already talked about some of these concepts in some of my earlier ramblings as I was just talking about some of my old war stories of being a principal. But it's worth it talking about it again. The main concept I want to talk about is that we are expected, of course, to ensure that our schools and the students and everything around are safe. We need to balance that with the concepts that we're dealing with juveniles, and so that reminds us that we need to deal with any of these issues, especially talking about searching a student, searching their backpacks, searching their lockers and cars and that kind of stuff. Handle it with as much tact and discretion as possible. Seeing it from the student's point of view, they are almost always intimidated when they're brought to the office, and they don't know what their rights are, and they may feel compelled to do things maybe they shouldn't do, or they just get scared. So the big part there is to treat students with respect anytime you're dealing with them in these situations. This is a touchy situation because you are dealing with someone's child. So anytime that I would be conducting a search, there's some things that I'll try to pass along that I learned over my almost 20 years of being a principal that I learned to do. On the shared screen here, if it's working properly, in general, school leaders should inform students in advance of the possibility of searches. That heavily comes into play. We're talking about the possibility of searching lockers and the grounds and the parking lots, things like that, cars that are there. Need to make sure that it's in your student handbook that with the concept of reasonable suspicion, that's what we have there, reasonable suspicion, that those items may be subject to search. And so you try to get that out well in advance so the students understand that things are a little bit different in school. Not entirely though, but I'll get to that in a second. Anytime that I would be involved with searching a student, often their backpack, for example, bring them in office, I'd have multiple people involved. I never would conduct a search with just me. I didn't want to get in that situation. And I would try real hard to be non-confrontational and low key. I learned that it's very easy to ramp kids up. It's hard to go the other way. So I'd be as low key as possible. I'd be very aware of my body language. And like we're talking about searching your backpack, it'd be on the table. I'd say I would articulate what my reasonable suspicion was that I had to concern. I would usually start with saying, this is why we're here. And I would use the phrase reasonable suspicion. That's what the courts have given us. It is a lower standard than probable cause that the school resource officers would have. And I would talk my way through it and say, this is the reasonable suspicion. This is what we think might be going on. And I would give them a chance to say, look, is there anything in this backpack that doesn't belong at school? And talk about it a little bit before I'd start looking. And I would, the student be right there. They'd be very aware. I'm not trying to hide anything, let them see where my hands are. And so there would be a witness there. And so be working our way through that. And we'll get to the more intrusive situations, but I just want to get across that students still have their Fourth Amendment rights at school. And the case that really established that, and I have a link here to it, is New Jersey versus TLO. This is a case where A student was found smoking. The administrator was looking for tobacco, kept searching, found rolling papers, led to evidence of drug sales, and it just all unraveled for the student. And it had to do with the principal looking for one thing and eventually finding more. And that the principal had reasonable suspicion to do that. And the court sided with the administrator. But during that court case, that's where the concept that the Fourth Amendment applies to search and seizure conducted by school officials. We are, like it or not, we are an arm of the government. And so we have to be aware of that. So we act as representatives of the state. And in the parentheses here, the prohibition of unreasonable searches applies to school officials. Now, again, the phrase reasonable suspicion comes into play. This court case gave us the TLO test, or two prongs, basically, that was a search justified at its inception? Was there reasonable suspicion to conduct the search to begin with? So that's the first part. The second part is the scope. Was the level of the search, the level of the intrusiveness of the search makes sense? If you're looking for a stolen pencil and you turn a kid inside out looking for that, makes no sense. And so you only use as much intrusion as you need to make the situation safe. So indicate the suspicion is reasonable. Okay, intrusiveness. The more extensive and intrusive the search may require more evidence to establish reasonable suspicion. If I can get to, I'm gonna stop share. Okay, and I'm going to share screen again, but from a different spot. Okay, so this is, I've told you before that I use a school law book to help me prepare for these little conversations that we have here. And so this is a graph and the school law book that I use, and I've had the citations for this last module. I think I did. So this is a chart to show the level of reasonable suspicion on the left, up and down, and the level of intrusion on the right. And so if you're looking at what it's showing us is that if you have a low level of reasonable suspicion, and like lockers, that you have a low level of intrusion. And so as what it's trying to show here is that you need a high level of reasonable suspicion to conduct a strip search. And essentially, I was told never conduct a strip search. And so you might find yourself in that situation. I would say if I was absolutely convinced that a student had a gun on them, then it would justify the removal of clothing to look for it. I've had people tell me, some lawyers define that anytime you're asking students to remove any of their clothing, then you're getting the level of a strip search. And so you have to have a lot of concern before you start doing that. And so I'm going to go back to share screen here again. Okay, so yes, if I was looking for drugs, if I thought a student had drugs, I had reasonable suspicion when I was assistant principal in a large high school. We knew that drugs were hidden in shoes. And so if we were searching a student for drugs, we would almost always ask them to take off their shoes and socks, and we would find things there. And so we could articulate the level of intrusion that would take place. Again, if you're looking for some minor thing, then your level of intrusion should be very minor. If you're looking for a dangerous item, then it all ramps up. And that's the concept. I think you probably understand that. So there's a quote here lack of specifics in a wide search for a large group without specific knowledge of rule violations is not reasonable. What that means is that you need to be able to articulate what you're doing. If you're searching students, if you're doing a mass search of lockers, you need to be able to articulate, because the parent's going to ask, community is going to ask, why are you doing that? And so you need to be able to articulate the reason behind. Does your school have a large amount of drugs and guns and violence, that kind of stuff, to justify, make it reasonable that you're conducting the searches that you're conducting. Don't forget that, I forgot to mention earlier, that if I conducted a search of any student, I always called home. I would get on the phone just as quick as I could. I tried to beat the message home, and I would tell the parents, look, this is what we had to do. I didn't find anything, glad we didn't find anything. And the older I got, the more I was able to talk one parent to another. I'd say, look, one parent to another, we just have to do these things. Sorry, and if I find nothing, I'd apologize to the student, and I would get them back into class. I try real hard to not march to classroom door and yank a kid out and that kind of stuff. You don't need to embarrass kids any more than you have to. Although, yeah, if I thought they had something on them that didn't belong in school, I'd make sure I had eyes on them from the moment that we asked them to step out to the time they get to the office, because of course, if they have something on them that doesn't belong in school, it'll disappear by the time it gets to the office. If you just sent a note down for them to come to the office. So there are some mechanics like that you learn being a principal, and if you really stop and think it through, that's how it works. Usually, if we thought a student had drugs on them or maybe a weapon, and usually there'd be two administrators. One of us would walk beside the student, one would walk behind the student, because there's a chance that they would slip their hand in their pocket and drop something out, and you wouldn't see it. And so just the kind of stuff that you learn being an assistant principal in a big high school. Strip searches, we talked about that a little bit. Canine searches, the threaded discussion in the videos in this module talk a lot about canine searches. And I was an administrator in school one time when the county made a big deal, the district made a big deal of conducting canine searches, and we brought the dog in and showed all the kids in assembly, and let the kids know that sometime next week the dog would be back, searching the lockers. And lo and behold, the dog hit on a locker really hard. And so we were all concerned, opened the locker, and there was an old pack of hamburger there. So the kids knew the dog was going to come in the next few days, when they had dropped off a pound of hamburger, just let it rot in this empty locker. And you have to have a little bit of sense of humor to be a principal too. So as we go down here, seizure of students has to do with controlling the movement of a student in disciplinary situations. And it doesn't seem to be a big deal in the court. I mean, you read about it, but I don't think there's not much I want to say about that. Police and probable cause. I think I mentioned in one of our earlier videos that, and there's court cases dealing with this, that if the school resource officer, if the police officer has much of a hand at all in the search, then you're probably going to be working at the level of probable cause. So as I said before, usually the police officer would be on the periphery, maybe just be watching from the doorway. And so I try to make sure that I can still operate under my level of reasonable suspicion. I think I've said that my school resource officer made it very clear that if I thought I was looking for a weapon, he insisted he shall be there. And that made sense. He was just watching out for everybody. And so, but I was also aware that I need to use the pronoun we were conducting the search, not the school resource officer. And that's just how it had to be. So again, we keep it at the level of reasonable suspicion, not probable cause. So I think that I've talked about a lot of this. I just want to stress that students have rights in school, whether we're talking about TLO, or we're talking about Tinker versus Des Moines, the courts have consistently said that students, adults, don't shed their rights at the schoolhouse door. And so that just reminds us that we're trying to teach our students the Bill of Rights and how to conduct themselves in our society. And so just remind them, remind ourselves, remind each other. And as a lead principal, it was my role to remind my assistants that the students still have those rights. I made sure that anytime I hired a new assistant principal, I spent a lot of time showing them how this should be done. The first time we had to search a student with a new assistant principal, I conducted it so they could see that I was an experienced administrator. I had taught legal issues, school law before, and I wanted them to see how to handle that. I remember first time we had a fight at a different building and had a new assistant principal. I took the lead so they could see how I wanted to handle getting the statements, how I wanted to show them how to separate the students, the things, the mechanics of handling a difficult situation in school. And the biggest thing, again, is to treat people with respect and be as calm as possible and be as level-headed as possible. Okay, that's about all I wanted to say. I'll put this video back in the course. If you're seeing it, it's in the course site. Please let me know if you have any questions. I'm going to stop share. There we go. I'm going to stop recording. And I think this is the last video of this course, and I've enjoyed creating these videos. And please let me know if you have any questions. Okay, stop recording.